Roll.
Okay. Can everyone hear me?
Yes.
Yes.
Yep.
Okay, good. Okay, Marlene Batista,
Here.
Chris Brogan,
Here.
Brian Caffarelli,
Here.
Jay Gross,
Here.
Pam Iacono,
Here.
John Matola,
Here.
and John Wynn.
Here.
Thank you very much. And if we could stand to the Pledge of Allegiance.
Pledge allegiance to
To the flag.
of the United States of America, and to the republic
for which
which
it
it
stands,
stands, one
one
nation,
nation,
under God, indivisible, with liberty and justice for all.
And justice for all. Brian, I think you're muted.
Actually, his mic doesn't indicate muted.
Yeah, you're not coming through, Brian.
Still can't hear you, Brian.
We still can't hear you.
I can't hear you.
Brian, we can't hear you.
I bet Lincoln didn't have this problem at Gettysburg.
Can you hear me now?
There you are.
Yes, there you are.
Okay. I don't know what happened there. So there was never any audio on my end?
No.
No.
Oh, you guys followed along with the pledge pretty well, I guess.
No,
that,
after we
lost
heard the
you.
pledge. After that.
Oh, you did? Okay. All right. Well, so the next item was the agenda item number 3, the informational item on public email comments, and those are all contained in the backup that's posted on the website under files and documents. Any comments on that from members of the commission? All right, moving on. So the next item is agenda item number 4, to hear, consider, and act upon the election of a commission secretary. Are there any nominations for commission secretary?
I'll make a nomination.
Yes,
I nominate Marlene Batista. I think Marlene has great skills and would do a great job in that role.
Okay, Marlene Batista has been nominated. Do you accept the nomination?
I do.
Okay, is there a second? And it looks like John Matola is being recognized as the second. All right, are there any other nominations for commission secretary? Are there any other nominations? All right, having been moved and properly seconded, let's vote on the nomination of Marlene Batista as commission secretary. All those in favor say aye.
Aye.
Aye. Any opposed? Any abstentions? Unanimously, we have elected Marlene Batista as commission secretary. Congratulations and thank you,
Thank you.
for your willingness to help out. Just for clarification to everyone here and watching, that Prue will continue on as recording secretary, and Marlene will work with Prue on some additional items to be determined as the commission secretary. Were there any other comments about that?
Look
All right,
forward to
then.
working with everybody.
Okay, thank you, Marlene. And then on to agenda item number 5, the heart of tonight's meeting that had been posted, which is the red line and charter review session with Town Attorney Baldwin and Commission Counsel Mednick. I see that Steve is kind of spinning in circles, so he's caught the gremlin that I had. But I don't know if Attorney Baldwin, you want to kick it off, and we can text Steve.
Steve
and
is
see.
there.
I'm
Oh.
here.
There.
Oh, there you are. Okay. Well, perfect. Gentlemen, it's yours.
All right, Steve, take us away.
So I'll introduce the session, but the town attorney is going to conduct a great deal of this. The red line, I probably should come up with a better name for it because it's more or less a visual red line. We're going to walk through the charter from the first article to the last article. And one of the reasons that I always like to have the town attorney available to do this is the town attorney lives with this document every day. I'm coming in as an interloper. I can read it, I can understand it, but he'll be able to tell us where the potholes are, where the problems are, and where things that I may think are problems turn out to be customs that work well for your town. Because I'll look at a provision and be critical, and he'll give me his 2 cents on why it works and how it works. So it's really important that we maintain a level of realism as we go through this process, and context, meaning what is good for the town of Fairfield. And so I will defer to my colleague and friend Jim Baldwin to start walking us through the document.
Okay, thank you, Steve, for that introduction. And I want to thank Steve for all the effort you put in so far into this endeavor. Steve and I have spent several hours in the past week going through the charter line by line, section by section ourselves. And fortunately, we're going to spare you doing the same thing tonight. We've identified some areas that we need to do some more research on our own, whether it's a statute or whether it's a history of a particular section for our own benefit and then ultimately for yours as well. But we're not going to dive into those issues too much tonight. So my presentation tonight is going to just fly through the charter. I trust that everyone here has already read it, I hope, from cover to cover. I hope so, because if not, I'm afraid that it's a necessary exercise for you to do so that you can make sense of it. So with that being said, I'm going to start from the top. The very first section, Article 1, Incorporation and Powers, Rights and Obligations, Definitions. I'm very happy with the way that is presented so far, including the somewhat difficult to understand definitions or distinctions between a town office, town officer, and town official. But when you read this document, it actually works quite well. The only comment I would make to that is that I think the office, officer, and official should be capitalized, but those are the kind of details that I think we'll skip tonight. I think that's something that Steve's already identified on his own, and that's something that the commission can certainly address. It's kind of low-hanging fruit. So the elected positions, I have nothing to comment on about those other than the question of the constables. And I confess, I've never used a constable, and I think that it would be appropriate for the commission to get one of the constables to present to you or to come before you to get their opinion on the subject, because I simply don't know enough, other than the fact that I know I've never had any interaction with any constables. We're going to get into, I think, some of the other town offices that are listed in section 1.4B, but generally speaking, I want to make the following comment, and that is that the term of these town officers, who are for the most part appointed, but not all, several are elected, is set forth or not set forth in that column to the right that you see. And that has caused some confusion. And I think, John Matola, you're familiar with that situation. And we'll dive into the language, but I think that what we need to do in perhaps those instances where it is simply not listed is perhaps make reference to the applicable charter section, which is section 3.3 of the charter that we'll go over later. So that would be my suggestion. And then another comment in terms of the terms, the building official is 4 years, for example, and the building official is is generally speaking a classified employee, and so that raises some other issues that I think we need to address with Mr. Hazelkamp, our HR director, and as well as trying to make sense of when that 4-year term begins. Is it when that person is hired, when they take the position, or should it be something much more consistent, such as the term set forth in section 3.3, which I think would make the most sense. Okay, now I've said my piece on that. I might add to it later when we go over some of those particular positions. So I'm just going to cruise through to Article 2 now, elected officials and elections. The eligibility requirements, I think, are fine. I haven't heard or seen any problems. Same with minority representation on boards and commissions. The terms of office, yeah, that's fine. We're gonna talk about the term. I think you've already gotten comments from Judy Ewing about some inconsistencies with the term and when people take their office, and I think that that's a very valid criticism or thing that needs to be cleaned up. We'll talk about that when we get to it. Yeah, this is it. So section 2.3D, the commencement of terms of elected officials. The confusing language here is that it says it shall commence on the 3rd Monday in November after their election and qualification. So I think what that intends to mean is that it's the 3rd Monday in November, period, not the 3rd Monday after their election and qualification, which is not necessarily the 3rd Monday, if you follow me, even though that's what it says. So,
Right.
because there are instances where the 3rd Monday after their election, all elections take place the first Tuesday after the first Monday. So that means that it would be the 4th Monday. And that presents some issues, and also presents some it's contrary to apparently the custom of having a swearing in ceremony for RTM members and other elected officials in the 3rd Monday of November of each year. So I think that's just something that needs to be wordsmithed by the commission. I just, it says right underneath it, just because it's right there, the terms of the justices of the peace, 45 justices of the peace shall be nominated. We don't have 45 justices of the peace, and I really don't know where that comes from, and I'm not sure if it's something that we might as well change to be consistent with the number of justices of the peace that we do have now. Maybe it's like the RTM membership, which says that it's a maximum number, but that's not what's said here. And by all means, if anyone has any questions, please give me a shout out. The resignation from elected office, I think is fine. The vacancies in section 2.5, I think is also fine. We'll talk later on about the exception to 2.5 with respect to the Board of Selectmen. But generally speaking, I think that it's fine and accurate. Now going to the RTM elections, I just note that the section 2.6A3, the RTM shall consist of not more than 56 members.
40.
Sorry?
40.
Yeah, of course we have 40. But by charter, you could have more. And it also stipulates, as the RTM has done, that the RTM can pass by ordinance to reduce that number or to have a different number. So I know there's been discussion about maybe changing the RTM, the size or whatever, but that might be an opportunity for you to do it by that language or not. You know, it's I just pointed out, I point that out to.
But the 56 members that it mentions here was prior to the realignment of the RTM in 2010. Pam, help me out on that.
So you're allowed to have up to 56 members, and we could have, when we redistricted through the voter reapportionment, could have enlarged our membership, or we could have left it where it was, which was at 50, or we could have made it smaller. And we compromised, the committee of 4 people, bipartisan, we compromised on 40. Two of us wanted to go to 30, 2 people wanted to stay at 50. The compromise number was 40. And then ultimately it had to go before the entire RTM, and it passed to lower the number to 40.
And that was
but we could have, if we so chose, redistricted and drew more. We could have we only have 10 districts right now. We could have gone down to 8. We could have gone up to 12.
12.
We had the flexibility there to do what we wanted.
I see. And that was enacted through an ordinance by the RTM.
That was done. Jim, was that ordinance? Or I don't know if that's an ordinance or that was because of the reapportionment.
It's an ordinance because elsewhere in the charter, it provides for the RTM to have the ability to make that reduction.
Okay.
Doesn't it say in the charter, and I forget where, that every few years when there's a census, that the RTM is required to look at its districts to make sure that our representation is fairly distributed?
Yeah, that's the section above, John.
Right above it in
Right.
subsection 2.
And that's what we had to do when we did. That's what we had to do when we met as a redistricting committee. We literally had maps in front of us. We had the voters in that district, and as we moved boundary lines, we had to make sure that we stayed within this. The smallest couldn't extend to 10. Yeah, that we were working within those percentages.
Yeah. So the process is dictated by the charter, by ordinance, and I think state statute to a certain degree too. So
Yeah.
we have to be careful with respect to what we want to do there, if anything.
Reapportionment is governed by state law ultimately. And so we'll have to look at this language to determine whether or not we want to have language that could be confusing or could be contradictory to state law. And as Jim mentioned, we're going to come up to the sections in this section actually that may be bumping up against state law. You have very detailed provisions in here on petitioning and the nomination process, and most of that is governed by Title IX. And I'm going through the statutes right now to see whether or not it just makes sense to rely completely on the state statute and not have provisions, even if the provisions are identical to what's in the statute. If the statute changes, then you've got a charter that can't change. which could be confusing to the public. So we'll take a look at those as we go through this process.
Okay, thank you.
And in that context, I'll just segue my comment and to what Steve said, and that is, I just have a sentiment that if we have a charter provision, which is valid because it was passed by special act and pre-existed the particular statute, I am of the sentiment that it's there for a reason, and it's the kind of the culture, as we call it sometimes in the town, and I would suggest that we keep it unless we think there's a problem with it. But with that being said, what Steve just said is also true, which is if we're just regurgitating language which is already in the statute, then it really doesn't need to be, not much more may need to be said. That's all.
That's a very good point that Jim just made. If these sections date back to your special act, Jim is going to examine that, then I think we should clearly reference in a footnote that these are derived from the special act. And if you think these processes are better than the state processes, then you keep them. If you don't, then you rely on the state statute. So we have to examine and make sure that those provisions are in fact derived from your special act.
Can I just say something else on this procedures for the RTM stuff? The section section 2. The other thing that the charter says is the committee has to be made up of an even number, an equal number of members from each party. If we could put that down at some point to have a discussion, I served on the second redistricting committee. The first redistricting committee ended up in a lawsuit in court. The problem, and as a result of that, the committee I worked on, we were committed to getting something done. But in that first instance, it was, what were you going to do when you can't get it out of committee because it was dead even and you're locked and then there was nowhere to go? So I think we ought to have a conversation about what's the tiebreaker? And I don't pretend to have an answer to that, but it definitely was an issue.
I've drafted some provisions in charters, and if this is an item that we want to discuss, I'll be able to give you different examples of how we get through kind of a log jam in reapportionment, where one of my towns has kind of two cuts at the apple if there's a problem. And you also have involvement of your registrars of voters, which is a pretty useful thing to do as well. So I've put down a note that that's an item that we should, that will go into the grid. And I do have provisions I can show you, pretty robust reapportionment provisions.
Okay, it's a classic thing about this charter is that I remember reading this and going over it with Steve just the other day about where it states that you can reduce or increase the number to a maximum of 56 members, and I can't find it. So to the point well made by several people, I think an index would be very helpful for the charter. And while I'm on that topic, I might add that any ordinances, anything in the town code which is covered by the charter or expounded upon, I think it would be helpful to have reference to that as well. That would be a huge help.
Definitely. I worked on it, didn't even remember it was by ordinance.
Yeah. Okay.
So I've actually got, this is Jay, I've got two questions there. So, so since there was an ordinance by the RTM to reduce it by 56, why to reduce it to 40? Why wouldn't we just change the number to, why would you keep 56 in the charter if we've already changed it?
The discussion then becomes whether or not, it's not just, see, when you're reapportioning, you can make a decision as to how many districts you have. And then, you know, if you want to go to 12 districts and, you know, you want 4 people in each district, or, you know, whatever the math is on that, you're leaving yourself the flexibility to do that. Personally, I wanted to go to 30. So, you know, I don't think that we need to be that big, but that's just my personal opinion. You know, the commission can have that discussion. But that's why that number is so the way that it is. It varies based on the number of districts that you decide that you want to determine in town. You know, as I mentioned before, you can go down to 8 districts. You can go down to, you know, 3 districts.
So my point is, if the town has already made a decision on something that contradicts what's currently on the charter, why wouldn't you update the charter to reflect what the town currently has decided they want that number to be? John?
So I was on the first redistricting committee that had the stalemate, and I think what Pam said is correct. It doesn't mean we're going to go it doesn't mean we want to go to 56, but it gives the town that flexibility. What if our population swells to 70,000 people? We want that flexibility because we want to make sure our citizens are being represented. And I think that's the reason why we can go as high as 56.
Well, okay,
it wasn't a decision. It was a decision at the time through compromise with the second redistricting committee to go down to 40. But that is a decision that, you know, 10 years from now can be looked at where we may want to go a little higher. I think that's the reason why we have it. But I'm certainly open to discussing it too. I just don't want to lock ourselves in. That's all.
No, actually, you said a very interesting thing, John. What you said is we want to make sure we have basically a standard of representation, regardless of what the population is. Whatever legislative body we have, whether or not it be RTM or potentially something else, it needs to have a standard of representation so that the citizens of the town, as our population grows or shrinks, that standard of representation is maintained regardless of population. That to me would make a lot more sense than some arbitrary number. But I'm the new guy, so.
No, I hear what you're saying. I appreciate that.
Okay.
If this is an issue that will be discussed, one of the things I'll be able to show you is how most of the other communities in the state operate. And we'll look at towns that are similarly sized, but most towns actually fix their number for their legislative body and also fix their districts. What changes is the reapportionment, the allocation, the district. It doesn't fix the districts geographically, it fixes the number of districts, is what I meant to say. And so that the big issue is reapportionment. And from time to time, depending on population surges, you might consider modifying the number of people on a council or on an RTM. But what you've done here, and it's certainly a privilege that you're entitled to, is set a maximum and allowed for the change to be made on a real-time basis by ordinance. That is probably not the norm, but if it makes sense, it's something you might want to do. But if it's an issue we want to look at, I'll be able to show you what other towns have and talk about the philosophy behind it, and so that you can make a judgment somewhere down the line.
I would enjoy that, Attorney.
That would be great.
Yeah.
Yeah, I think also if we look at the state, the way they do it, they actually do it the way it's done here. They allow more state representatives than are currently the 151. So I mean, that's something I think that they're considering as well as they look to reapportionment and redistricting, is in fact maybe increasing the number of state representatives. So that, you know, there's precedent for having it this way.
Okay, and the second question I had relative to something that Pam said, and I want to make sure I understand Pam's point. Were you really focused on tiebreakers for apportionment, or are you concerned about having a tiebreaker mechanism within the charter regardless of what the issues are that come before any of the governing bodies? Or
No,
we,
I was specific. My point was specific to this one because we,
okay.
John was on that first committee. We ended up in court over the whole thing.
Okay. Thank you.
I think the state could give some guidance on that too. I mean, there's a tie-breaking mechanism there. I mean, they do seek to have a bipartisan committee, but they do have the committee itself elect that odd person so that there's an odd number.
Yeah, I mean, it's great. It was really incredibly helpful, I'll be honest, to have 2 Democrats and 2 Republicans working to figure that out. But, had the team that I was on not committed to making sure we got something out and got something done because the other one had failed, we could have ended up in the same exact situation all over again. We're just 4 people in a room staring at a wall.
I may be not fully knowledgeable of this, but it was my understanding that at the state legislature, they have a judge or somebody who is kind of the facilitator, much like a Steve Mednick, who tries to bring the parties together almost as a mediator. It might be something to look at instead of having to go to court, to Pam's point.
What you want to try to do is you want to try to establish a procedure that almost avoids the possibility of stalemate, is what it comes down to. And I've got some examples that I can show you as we go through this process.
Okay. So you want me to move on here? We're the vacancy provisions, the resignation provisions for tied elections, I'm perfectly comfortable with, even though, as Steve pointed out, it's not completely consistent with state statute, but I believe that this predates, and this is one of those home rule provisions that supersedes any state statute. And I have no changes or proposed changes to make, but you might want to take a look at it yourselves and compare it to state statute. So
before we move on, Jim, was there recently an issue that caused a special election to be required for a seat on the Board of Selectmen? And did that deal with the resignation and vacancy? And there was something that was unclear in the charter which caused the whole situation related to that?
There was litigation that I'm very familiar with, and I would submit to you that that the charter language is very clear, and by a 9-0 Supreme Court decision, they agreed with what I think is the plain meaning of that section with respect to the resignation of a selectman. And we can get into that now, but I was gonna get to that when I get there. It's coming up.
Okay, very good.
So I'm now going to jump to Article 3, appointed officers and permanent boards and commissions. This is where we find that section that I mentioned earlier, section 3.3, the terms of office. So this is with respect to the appointed town officers and not elected. And there it says that they shall that shall commence the 4th Monday in November. I don't think that that's inconsistent, and that's not a complaint that Ms. Ewing had. But it does speak to those town officers that I mentioned earlier that have nothing in the column for a term, and why I think we should at least reference section 3.3 of the charter, this section, to make it more clear. And I'll be very frank with you, some of those officers, 2 of them to be exact, myself as town attorney and the director of economic development, serve at the pleasure of the first selectwoman, whereas all others presumably either have a set term or the term set forth in section 3.3 if it's blank. And I believe that's an important provision because, as John Matola knows, it's got the language there that says, let's see. It says that, where is it? The election. Oh, here we go. That person's term shall continue until the fourth Monday in October, unless there's a vacancy and the appointing authority, whether it's the Board of Selectmen, the first Selectman, does not appoint a new town officer by the fourth Monday in November after an election. The former appointee shall serve as a continuing town officer or member until either the appointing authority fills the vacancy or until the 65th day after that fourth Monday in November. And what that means is that these are important members of the administration, be it new administration after an election or an existing administration after an election. And I think that it is within the proper authority of the chief executive or the Board of Selectmen, if it's an appointment made by them, to be able to not reappoint somebody in that position without having to say that it is for cause, which is a much higher burden and a more difficult standard. And this gets back into the question of someone who is a what do we call them, Steve? Sorry, I kept blanking on this yesterday. They're
Let me hear what you were saying again. I was just looking something up.
they're union members, or they're members of a union.
Classified,
right?
classified civil
Classified
servant. John Matola would know that. Okay. Yeah.
Right. So I again bring that to your attention. I think that's the intent and the proper intent of this section, but maybe it needs to be clarified.
Well,
Yeah.
can you actually clarify that, Jim? Because how does the first select person, if the person's in a bargaining unit, how are they serving at the pleasure of the first select person?
Well, John's shaking his head no. So
Not.
right, but how many of
Those
how many-
people.
So that goes to my question as to how many of those officers that we see in section 1.4B, how many of those are
In a union.
not in a union? How many are?
Not in a union, right.
Right. Like the controller's in a union.
Right.
So one of the things that Jim and I talked about the other day is we really need to sit down with Jim Hazelkamp and really figure out who's aligned where, who are the classified employees, and then we could fix the charter once we realize who they are. And then you need to figure out what you want to do with the rest of them. One of the issues that Jim has raised, he raised it briefly already, and we'll probably focus on it in a few moments, is when does the term of office commence for people who are appointed by the first selectman or the Board of Selectmen, for that matter, or by any other board and commission. You have that a series of executive officials who are appointed by boards and commissions. When will that term commence? Are they classified? Are they not classified? And I think that'll be a pretty simple exercise that we'll go through with Jim Hazelkamp, and we'll report to you on their status, and then we could go around fixing the charter to make sure it relates to reality. It's kind of reverse engineering the charter to meet the requirements.
So the result of that is just they're classified. They shouldn't be appointed by the first select person. Is that what you're saying?
They would be, well, you know, they would have to go through a hiring process. And if you had civil service, they go through a civil service system or merit system for their hiring. I'll defer to John. I'd have to think about some of the other jurisdictions. I'll have to talk to Jim Hazelkamp, who I think is an outstanding personnel expert, whether mayors do in fact sometimes hire people for classified positions if they're at department heads. There may be some room for that, but once they're in the position, they're classified and they can only be fired for cause in accordance.
Oh, gotcha.
with
So it's the
collective bargaining
back end
agreement.
provision then. Got it. Okay.
Got it.
That's right.
Was I okay on that, Commissioner Mottola? Okay, good. All right.
Yeah.
Yes, you are.
Yeah, I would not deviate from the appointing authority for that reason. But
Got
the
it. It's
rest-
the back end of it.
Right. Yeah. Okay.
I have another comment on minor one on 3.3 on that. The Ethics Commission, the terms commence in July 1. When I was on the commission, we had problems because of the summer RTM wasn't meeting or somehow it got lost, but we had this period without having a quorum, which we got through, but it was a little bit awkward. So I think maybe I don't know why it was July 1st. Maybe they wanted to give the RTM time to get up and running before they appointed it, but we probably pulled that back a little bit or later, maybe even, but the summer was a bad time to have it.
I totally concur.
May I ask a question? And Jim, I didn't notice this the other night when we were, or when I read it the first time, but going through it right now, I see this. I have never seen in a charter a provision that says unless otherwise provided by ordinance, which allows an ordinance to override your charter. It's the opening clause of the section in terms of office. It sounds like you may permit an ordinance, an action of the RTM, to override a provision of the charter by modifying commencement dates for boards and commissions.
And we have that actually. So
Well,
the
I'm just saying
FairTV
that's unusual, is what I'm saying. That's all.
Okay. Yeah, like FairTV, we appoint them, and I think the same thing July, and we shouldn't. Chris is 100% right. Most of the time, we're trying to cancel and recess for the summer. So.
Yeah, I would just submit that there's probably a good reason why it's not the same as the others. So if you were to change the date, I wouldn't necessarily be consistent with all other terms right after an election, but rather have some buffer built in per the intent of the people who wrote that provision many years ago.
Yeah, that makes sense.
Do you have staggers on your commissions, or are they expected that they'll all run out when a new mayor comes in, so the new mayor appoints the entire commission?
They're staggered.
They are staggered.
Yeah.
Thought that. All right.
Okay, so resigning from appointed office, et cetera. Again, that only begs the question as to the term. When does it run? I mentioned that before. Does it run when the 4 years? If it's stated to be 4 years, does that mean it's 4 years from the time of the appointment of the new person or not? And I would think that it's best to be consistent with 3.3 above. And whether that needs to be clarified or not, I leave it to you, to your commission. 3.6, the removal from appointed office for cause. As I said earlier, there are 2 officers, myself and the Director of Economic Development, who serve at the pleasure. And so all others, you typically speaking, we're talking about directors of a department, must go through this procedure, which is very similar to a loudermill, right, John? Would you agree with that? I don't see any reason to change it, I guess, is my final point on that. All right. So now we move back to the RTM, the legislative branch. And I don't have any suggested changes other than
the only one is you want to get rid of the assistant town attorney reference in 4.2A.
I'm talking about the legislative branch, Yeah, we're not there yet.
No, if you go down to 4.2A, assistant town attorneys are considered to be ex officio. It's on the point. Yeah.
No, that's a good point. Well, yeah, I'll
You're going to deal with it later, but I just thought I'd earmark it now that it's.
got it. Yep,
that
that's
they're
a
here.
good. That's why you're here, Steve. Thank you. And then some. The only other thing I think you already heard from Betsy Brown, the town clerk, about the notice provisions, and I would wholeheartedly agree with her recommendations and suggestions on that point.
I have one question, and because I have a member, at least one member of the RTM on this call, on this commission, the issue of 4.2B, judge of qualification. Can somebody tell me what the origin of that provision was? And because and there's another provision later on where the moderator certifies, in effect, that the members are elected. Aren't they certified on the night of the election or thereafter, depending on how many absentee ballots we have to count? Once they win the election, are they then certified? I don't understand these internal provisions as to why the RTM should be the judge of the election and qualification of a member. I'm not sure what that means.
I don't know the history of it either. I don't know if you do, John. To my knowledge, I've been on since 2013. To my knowledge, we've never had to use that clause.
I don't know what it means either. I've never seen it in operation.
Like, we decide whether or not they're qualified if there's an issue? I don't even know where we would use that.
You know, it may possibly go to the residency, or whether they're an elector, or whether they reside in the district, because you can run for an RTM office, and I think the language says that you must be living in that district when you take office, but not necessarily must you be in that district when you are a candidate.
It also
So,
may
Jay,
go to whether there's any ineligible conflicts. I know there's some language elsewhere about you can't serve on this and be on that. And I think they get to judge whether that has happened for the RTM members.
And you could have an RTM, someone who's elected on the RTM, but moves.
Right.
And doesn't say anything, and there's an issue and doesn't resign. And I guess at that point, the RTM, now it says the RTM shall be the judge of the election, but it does also say qualifications of its members. Someone moves out of district or moves out of the town, they're no longer qualified, and I guess the RTM could act to remove that person if the person did not voluntarily resign. I don't know.
Bring a
That
quo
makes sense.
warranto, bring a quo warranto action or something like that.
Right.
Or they wouldn't
Yeah,
have
removal
to.
from office.
Or they wouldn't have to in that instance to bring such an action, Steve, because you have this provision. That's a good point,
Right.
John.
Yeah, it brings us into the thorny issue of removal of elected officials. Of course, you know, you can't do recall in the state of Connecticut. And I've devised removal provisions in charters. And as I'm doing my fourth charter in Hartford, and we put the removal provision in 20 years ago. And thank God we haven't needed it, because I'm hoping that we don't have a constitutional judgment on any of those provisions I've written. I believe that you can do a removal provision and not a recall provision, because it's really part of the operation of the government and how you conduct the government, the level of integrity, the issue that several of you brought up about residential requirements and things like that. And I laid them out in a very similar way to your section that Jim was just talking about, 3.6, on the removal of the appointed officials. I've developed some removal for elected officials that lay out, delineate grounds for removal, and so maybe this is actually an interesting provision in that regard. If you have the legislative body make a determination that somebody is not eligible, no longer eligible, I was looking at it as kind of a certification, but it seems to me that what this is kind of saying is that the town clerk could certify the election, but by the time you convene 3 weeks later, roughly, somebody has determined that they live in Westport. They don't live in Fairfield. They've just been giving a bogus address. And this would be, you'd have some procedure to make that a due process determination, and that could lead to the removal of that member. We may want, if that's what it's intended to do, we may want to clarify that. That's all I'm saying.
I don't know.
And
Betsy might know.
Yeah, I was curious if it was ever used. That was my. All right.
It hasn't for the 8 years that I've been around.
All right. I don't want to take too much time, but I just wanted to raise that issue.
There was an instance not too far back where a couple of members, or at least one to my knowledge, was no longer living in the town of Fairfield, but they resigned rather swiftly, so this didn't have to be invoked, but perhaps that's a situation where it would have been or could have been.
Okay.
So jumping through to the RTM, again, I don't have any other observations to make other than what the town clerk has already provided you with.
It's underscore that she emphasized the newspaper provision, that we want to make sure as we go through the charter that we take a look and make sure we modernize our ways, the mode of notice. I think I just wanted to point that out, because that's a fairly consistent position that she has taken.
That's right. There's a 4.5 regarding ordinances, the newspaper references there. And then I believe elsewhere where she's supposed to deliver certain items or notices to members, and the physical delivery should not be necessary either, or the definition of delivery should be better defined for our modern age here. So without any further questions or comments, I'm going to move to Article 5, the executive branch. And my comment here has to do with Section 5.3, official bonds. I think that is kind of an archaic provision, and the town is fully insured for all sorts of situations. And our most recent thought of invoking this or taking advantage of the bonds, it was learned that they really don't exist, and they have not been, this provision has not been followed for quite some time. And so query whether it's even necessary to have it in there.
And I mentioned to Jim that these provisions likewise are in a number of charters throughout the state, and the culture, I think I talked the culture of noncompliance, or this is one of those examples. I'm going to put in a call to people at Kerma, which I think provides insurance for Fairfield and many of the municipalities in the state, to see what if there are any best practices that they have, and maybe the charter should reflect what the best practice is, and so as opposed to an archaic provision.
Okay, thank you, Steve. So I'm going to jump now to Article 6, the Board of Selectmen and the first Selectman. And the most glaring.
Jim?
Yeah.
And I guess this question is to both you and Steve, and I guess everybody in general. I understand the process we're going through right now is to look at the charter as it stands today, and look at what needs to be tweaked, improved, taken out. But I was wondering, since we're on the area of form of government, would it be possible to get a discussion or a presentation, Jim, by you and by Steve, on the various forms of government and what the pros and cons are? I mean, we do have to go through this process here, look at what is, essentially on the table. But me personally, I'd like to open the aperture a little bit and consider other more effective ways, or I don't want to make that judgment, but I'd like to at least understand what the trends are, other towns in Connecticut and elsewhere, in terms of what they're doing in terms of forms of government.
Jim, would you mind if I?
Steve, this is in your wheelhouse.
Okay, Commissioner. So the in two meetings, I'll have the chair correct me if I'm wrong. We're going to be doing our level set meeting, and so I fully expect that the issue of government governance is going to be a significant issue. What we're trying to do today is we're looking at the nits, and it's proper for you to take a look at the more global issues. But this commission is going to make a determination 2 meetings from now as to what our priorities are. But let me give you a little preview, because I'm assuming that this is an issue that you're going to want to look at. What I generally do is I generally will give you some comparative data to show you the forms of government in communities that are similarly sized to you, a few cities above you in terms of the size that you may be moving toward population-wise, and some of the cities just below you. I'm not going to, Goshen, Connecticut will not be on my list. Morris, Connecticut, Woodstock, Connecticut will not be on my list. But you will see communities that are of equal size to see those structures, what they look like. So that'll be a visual look at what communities of your size look like in terms of governance, whether there's council manager form of government, mayor council form of government, first selectman, RTM, first selectman, town meeting, which we probably moved from some time ago. So you'll see all those structures visually on a comparative chart. The second thing I will do, with the permission of the body, obviously, would be to put together panel discussions where I will bring in practitioners. I will bring in colleagues of your Board of Selectmen. I'll bring in first selectmen, mayors, town managers, city managers. Some of them will be current practitioners. Some of them will be well respected. I try to bring in people that I think have some breadth of knowledge, who are advocates for the form of government that they care about. And the other element is I will probably look to the academic community and have a few academics from some. We're very blessed in the state to have some remarkable institutions. So I just went through something on boards of education in Hartford, where I had professors from Brown, Northwestern, Rutgers. So I'll try to put together some really good panels that will be available to present and then answer your questions. And I've been very lucky with our panels. So that is my intent, if that's an area that the commission wants to go to. And I just recently went through this exercise in a mayor council form of government that was thinking about going to a council manager form of government, but and had a really terrific scope of performances for the commission. So that will be the game plan.
Thank you. That sounds perfect.
Can I just point out, it's Pam Iacono. I got a text message from someone from the public who's listening on the phone. They just asked if we could say our names before we speak because they can't tell who's talking.
Okay.
This is Jim Baldwin, and that's something that I usually say, and I'm guilty myself. So that's a good point.
So this is John Wynn. Just to follow up on the point that Jay Gross and Council Mednick was discussing, one thing that would be helpful is you mentioned 3 or 4 different forms of governance that are used around the state, and I understand different communities will use different ones, but to, in a summary fashion, identify this form of governance, whatever it might be, is typically used in communities of for this purpose, or this is when it's effective and this is when it's ineffective. Like a town meeting form of governance is sometimes viewed as ineffective because of the difficulty in getting, people together and having a good, deep discussion on a topic. And other forms are more effective because they help towns achieve that objective. So that a very, very quick overview of that for the 3 or 4 major types of governance structures we would consider, I think would be helpful for me anyway.
I think for the public as well. I think as much education we can provide would be beneficial.
And this is Steve Mednick responding. That's what I try to do with these little seminars, is to make sure that we have fairly broad information for the commission, because governance is a critical issue and it's one that the public is going to want to weigh in on. So you will have, I didn't mention this, in addition to the comparative documents I'll put together, I do try to provide you with some really good, not treatises. I don't want, unless you're having sleep issues, a sleep disorder, I try to provide some, good, pithy, smart pieces on different forms of government so that you can understand what it is we're doing. And I'll also point out that we're limited. There's only so many forms of government,
Right.
and I won't get into it now, that the state allows us to do. So so we will have some limitations.
That would be
Yes,
excellent. Thank you.
I guess well, never mind. Go ahead, John.
John, I was just saying that's excellent. Thank you.
Okay, so this is Jim Baldwin again, town attorney. I was going through the executive branch in section 6.1 and specifically the glaringly archaic provisions set forth in 6.1C1 with respect to the Board of Selectmen having to approve every contract that is entered into by the town, except for those less than $10,000 and for a duration of 3 months or less. It's very unwieldy and it's very cumbersome. And I can assure you that when the members of the Board of Selectmen come before you, they will say as much themselves. So it's just something that needs to be looked into. That's not to say that this provision doesn't have importance, and there must be some degree of oversight, certainly by the Board of Selectmen, in my opinion, to such contracts. I might suggest maybe language, and this, I'm just throwing this out there, that that speaks to contracts that have not been for which there's no appropriation, or it has not been already considered, whatever the project is, by the town bodies in the usual budgetary process, because that's always the first question when a contract comes up for review and approval by the Board of Selectmen. Have we appropriated money for this? And 9 times out of 10, if not more, the answer is yes, and it's coming from this budget, and it was part of this line item, which was addressed at the budget meetings that, of course, went through all the Board of Selectmen, the Board of Finance, and ultimately the RTM. But that's something that does need to be addressed. But while I'm on the subject, I'll also mention that the Board of Finance, as Mr. Mottola is well aware, has the authority pursuant to the charter to set the procedures, the purchasing procedures for the town. So there is some oversight right there. Not to mention the oversight that should be done by anyone sitting in my position as town attorney. They should, of course, review these contracts to make sure that they're well done and the town is protected, adequately protected.
Jim, this is Jay Gross again. So I just want to make sure I understand. Is your concern that you want to set up, because it's typical in most businesses, you set up delegation levels of authority. So the CEO doesn't make a decision on every single contract or approval. Are you asking for a delegation level, a little bit more detail, a little bit more? Are you saying that selectmen should should only need to look at things, and I'm just making this number up, $100,000 and above. And below that, we have various delegation levels.
Yeah, that's certainly a possible fix, but the problem is there, that every single contract, even though, as I said, it's already been anticipated and approved conceptually by the town bodies, needs their formal approval. And it's just very cumbersome and I believe unnecessary. And I think that the members of the Board of Selectmen would agree with that. But we certainly need to keep in place some form of oversight or checks and balances, without a doubt. But I just don't think that this is the appropriate way.
I see. So you're saying that the project's been approved, the funds have been approved, but yet it's got to get voted on a third time.
Right. We've got a building committee and we're hiring an architect. And, you know, every project you have to hire an architect. And for the charter, you have to have that standard AIA contract approved by the Board of Selectmen. And I think that that's the situation that we should try to avoid.
Okay. Yep, I got that.
This,
okay.
This is Steve Mednick. This is an owner's provision and looks like an ancient provision with the dollar amounts that are involved here. Very often, a charter will talk about to make sure that contracts can only be executed if they're within their appropriation. And so you can govern it that way. You could create a much higher cap. Although if it's appropriated, if it's a technology system and the technology system either is on the capital side or the general fund side, if the monies are appropriated in the budget, that should be the issue for the administrators that have to do this. And presumably the Board of Finance will lay out a system that will create the checks. So the provision should really make sure that there are appropriate checks, but this is a very low number.
And there are this is Attorney Baldwin again, there are lots of ways to do it. I mean, I could picture when something is passed by the town bodies, let's say it's the Board of Finance, they can stipulate that they want to be sure that the contract is reviewed by them or by the Board of Selectmen. I don't see where that would be precluded. Just kind of spitballing here, you know, it's an issue that sorely needs to be addressed, and the details, you know, aren't certainly going to be worked out in this meeting, but I'm just bringing it to your attention. All right, moving on. I do not have anything further with respect to the Board of Selectmen, unless anyone has any questions. This is Attorney Baldwin again. I will move on to 6.3, the vacancies in the Board of Selectmen, and I'll just reiterate what I said before, that what 6.3 does is capture, or I suggested this before, what it does is it captures kind of a long tradition that was followed by members of the Board of Selectmen, particularly when we had the Board of Selectmen for a 2-year term. And that tradition was, when there was a vacancy, the vacancy would be filled by a member of the same party, as it's required here in 6.3, and also required by the language of the statutes that address this issue. What's different about the town of Fairfield is that, unlike the statutes, it stipulates that if the vacancy is not filled within 30 days, it shall be filled in accordance with the procedures set forth in Chapter 146 of the General Statutes. Section 146 of the General Statutes stipulates that in any case where there is a vacancy, there was always the opportunity for there to be a petition filed of 5% of the electorate to have a special election. What differentiates or distinguishes the town of Fairfield from that statute is the if language, if it's not filled within 30 days. And the tradition in the town of Fairfield has always been, up until recently, that the wishes of the party or of the member on the Board of Selectmen who's lost a fellow member, or just what am I trying to say? The tradition has been that you respect the person who's been recommended by the other party, so long as they're, generally speaking, acceptable and known, and that's never been an issue. But with the change to a 4-year term, that became more consequential, I would say. And so that's why we had the issue that came up a few years back with respect to the question of whether you follow the charter or do you follow the statute. And the Supreme Court clearly ruled that because this pre-existed, that statute, and it's always been in there in the town charter, that the town charter supersedes state statute. And I think it's, by the way, just my own editorial, I think that that's a fine tradition and a kind of custom that the town has had for many years, and I would like to think that it would still be followed. Yes, John.
I'd say something on that. So, and I haven't looked at that case in a while. So you're saying, Jim, if the vacancy is not filled within 30 days, then it can be filled pursuant to the procedure set forth in Chapter 146, and that's the petition part of the state. Am I misinterpreting that?
No, that's correct, John. This is Attorney Baldwin. That's correct. But before you get to the petition stage, you do go through several other levels of going to the town committees first and having them vote and have nominations. And I can't say it from rote memory, but you do have
Right.
other hurdles to go over, or procedures, and then only then, once that person is chosen, then the public has the opportunity to file the petition for a special election.
Okay. So let me just throw this out there for the committee's concern. I think, Jim, this is John Matola speaking. I think you kind of made a very important point that this section was written when we had 2-year Board of Selectmen terms. My concern is we have an election and you have a first select person or someone on the Board of Selectmen who passes away within the first 3 months of being in office. And so under the way this is written is, and I got to use this term, we're stuck with someone who is holding a very important position by appointment pursuant to this section. And I just think we need to kind of take a look at this to see if that's how we want, if we're going to keep this form of government, obviously, if that's how we want to operate. I personally don't like someone being in such a high position who's filling the vacancy for a number of years without having to go through the electoral process. And that's just a thought. We don't need to debate that right here, but just something to keep in the back of our minds.
Yeah, this is Jim Baldwin again. I'll just, the dynamic that is also in play here is the fact that, the first selectman runs as first selectman, and usually, 9 times out of 10, the person elected to be first selectman, their running mate is also elected to the Board of Selectmen, and I think there's a reason for that, and it's kind of baked into the equation. So what you are then doing is you're deviating from this team election, that usually happens, and now you're separating out from that one person and having a special election, so that dynamic is now gone. And I just bring that point up to maybe explain why, in part, this provision is in here. And I'll also remind you that all you have to do, if you're a sitting member on the Board of Selectmen, is refrain from voting or vote against that person. In which case, if 30 days passes, then you kick in and you can have the special election. So you're not precluded from doing that. It's not automatic. It's only if the person is put in the seat within the 30 days of the
Gotcha.
vacancy.
All right.
So John Wynn here with just a follow-up question on that. If this provision was changed through whatever we ultimately discuss and modify it, does that allow the state statute to jump in front of precedent in this case because we have vacated the portion of the town charter that existed prior to the state statute? I don't know if that's confusing.
Steve, this is Jim Baldwin. Steve, I'll defer to you on that. I don't claim to know the answer to the question.
Yeah, again, I don't know unless Jim tells me. This is Steve Mednick, I'm sorry. I don't know whether this provision is part of the special act or whether it's just a home rule provision in your charter. But
this is Jim Baldwin. I can answer that question. It's pursuant to a special act.
All right. So just to repeat, just from a editorial perspective, I think we really should annotate the documents so that we know when something is a special act provision. I think that would be useful because it would be it would just make it easier so that we don't know if we're going to perform surgery. We want to know what we're giving up if we think it's a good thing, and if it's a good thing, we should keep it because once you get rid of the special act provision, then you're operating completely under home rule, and you have the ability to do many of these things under home rule. Most of what's in here is not unusual. The issue that Commissioner Mottola brought up a few moments ago with the 4-year term is that there's a slight modifier, and what a lot of communities do, and we don't need to debate it right now, is you can bifurcate the filling of vacancies so that for a certain period of time, it would automatically go to a special election, and at a later point in time, it would go to an appointment. There comes a point in a term where it doesn't make sense to go through the expense of going to an election. The longer you have left in the term, the more likely it is the town would be willing to expend funds to fill a position. And that's what a lot of towns do. I think Bridgeport has that. I know New Haven has it. Hamden has it. I'm trying to think of the various communities that I know really well. And so you can do that. But again, there's another theory. If it ain't broke, why fix it? That's another thing you need to think about. But it's certainly something you could look at. And the 4-year term may come into play in your thinking. It's something that you should think about.
Actually, this is Jay Gross. Steve, you said something that I was wondering if there is a way to annotate what provisions in the charter are required by state statute versus those things that we decide to include optionally.
There's only, I'm sorry, Commissioner.
No,
there's only 2 provisions that are absolutely required in a charter. One is to establish your legislature and to establish your executive. Everything else in the charter is left to the community to decide what they want to place in their charter. And those are the only 2 absolute statutory requirements for a charter.
Thank you.
Okay, without any further discussion on that topic, this is Jim Baldwin again. I'm going to jump to Article 7, elected officers. And the only comment I have with respect to the town clerk would be 7.1B3, which is brings up the deposit all money required to be collected by the town clerk with the town treasurer, with whom the town clerk shall file a full statement of receipts at the time of each deposit. I question 2 things there. Must we have a town treasurer? What purpose does the town treasurer serve in today's modern government? And 2, well, I guess on that basis, maybe it should refer to the finance director or the office of the Director of Finance instead of the town treasurer, which I believe is how it actually works these days. It doesn't go to our town treasurer. So I think that office itself should be looked at. And if you decide to keep it, then nevertheless, perhaps we should modernize this to sync up with what actually has been happening for probably decades in the town of Fairfield. 7.2, the other elected officers, I touched on this earlier about there being 45 justices of the peace. I don't think that we have that many, so that should probably be reconciled. Now I'm going to jump to Article 8, elected boards and commissions. And
Before you do that, should we
Yeah.
talk about the people in their bobbies, the constables? I think you referenced it earlier, but 7.2A, we also create 7 constables. This is Steve Mendick, I'm sorry for the record. So
Do we have to have constables?
do you have them? I don't do you have to? I don't think so. Do you have them? I don't know.
We do.
I think we do.
This is
Oh, you
Jim
actually
Baldwin.
do?
We do. They're elected every 2 years, and with all due respect to our duly elected constables out there, who I'm sure are listening, you know, I think, as I said before, you should probably hear from them and figure it out from there whether it really is something that we need in the town today. Good point, Steve. Thank you. All right, now moving on to the elected boards and commissions. The comment, this is Jim Baldwin again, the comment from, I think, our tax assessor addressed 8.3D, as in David, with respect to the assessment system. I think his point was that this language is probably archaic, and before the assessment systems, I think, were modernized. And also, I think there are state statutes which speak to the different assessment systems that can be used by a municipality during a reassessment. And I believe once every 10 years, or reassessments happen every 5 years.
5 years.
Yeah, and in one 5-year assessment, you could do it kind of mathematically and by models, and in the other, the next one, I believe the state statute requires you to do an actual home or house inspection. So again, to the tax assessor's point on this, is this really something that's necessary? I know Ms. Matola had some experience discussing the assessment system a year or so back, and this subject came up. I don't know if it's something beholden to the Board of Finance. Is certainly within their purview to look into the assessment systems, but I think you're quite limited as to what that is going to be. In terms of who gets hired, again, that's a contractual issue. All right. If there's nothing else,
I think, hey, Jim,
Yes.
on that one is John Matola. I think you probably might want to hear from some Board of Finance members on that too, because we get a presentation on this every year. So I think you're going to have to hear from a couple of us on this. Maybe Mr. Brown. Yeah.
Yeah, this Jim Baldwin. I think without question, that's something that should be addressed by that body when the time comes for them to present to you. Absolutely.
Thank you.
Excuse me. This is Chris Brogan. Jim, is your point just to sort of leave it to the state system rather than trying to address it here and create our own?
Yes, Steve. This is Jim Baldwin. I don't think there's any real distinction between the state system and what's here. It's just the state system. It's an example of where we're just trying to reiterate what is already in place with state statutes that must be followed.
Okay, thanks.
Okay, so I'm going to move on. I have nothing further on any of the other elected boards. Unless someone wants to speak to something, I'm going to go next to Article 9, the appointed officers, and we touched upon the town attorney and assistant town attorneys, and I even mentioned it at your last meeting, and I would submit that the assistant town attorney position is something that is also archaic and outdated in today's legal world. Unless we have a full-fledged legal department, which I'm not advocating for by any means, unless you have a full-fledged legal department, the reality is that when you need a specialist, whether it's a labor attorney to negotiate labor contracts or deal with such issues, you go to the best, or you go to someone who's qualified. And it doesn't necessarily mean that that person is an assistant town attorney per se, but it really means that there is no practical use for this language or the provision that's set forth before you.
This is Chris Brogan. Jim, does that mean that if the town determined, the Board of Selectmen determined that they would like a full-time attorney on staff to handle the more simple legal matters, that would be still allowed if this language wasn't here? Or think about it if you don't have an answer.
Yeah, well, I think that's Jim Baldwin here. I think that's a good point, Steve, and why I suggested that unless you're going to have a legal department, yes, you're right. Maybe I don't think you would be precluded from having someone hired in that position. There's nothing in the charter that says that you can't.
This is Steve Mednick, if I may. I was going to recommend that we add language under the town attorney provision that basically gives him authority, makes it clear that he has authority. I think it's implied anyhow, because it's talking about providing necessary legal services, but make sure he has the very clear authority to hire such attorneys as needed to be of assistance in representing the interests of the town. So I think to eliminate the assistant, you should replace it with the modern version of that, and that is going to the right lawyer for the right project.
Okay, thank you.
And Jim
This is
Baldwin,
Brian.
okay. Go ahead.
If I could ask Attorney Mednick a question, just in your other towns, has this come up, the assistant town attorney? I mean, is there some reason that we're missing that we're like?
In the larger cities, you still have offices. You have corporation councils have offices with deputies and assistants. New Haven, Hartford, Stamford, Waterbury, all the large cities do. When you start to get down to the smaller side, and maybe I think West Hartford might, but as you get down to the smaller communities, although Middletown's a smaller city, they have a general counsel's office with line lawyers within the office. But some of the smaller towns have moved from the model. I'll give you Hamden, for example, has historically had a town attorney and a number of assistants, but and they always hired a town attorney who was not a full-time employee of the town and had a couple of staff lawyers on staff. And I think what a lot of communities have come to the conclusion on is that you can't, at that level, with a small legal staff, really provide the level of service that you need to provide in the modern world. And so even towns the size of Hamden, which is roughly equal, I think that there are a couple thousand fewer population-wise than Fairfield, have made the judgment that their town attorney should have the flexibility to hire the attorneys as needed to represent the interests of the community. As you get bigger, John Mottola is in an office that's a pretty mature, substantial in-house general counsel's office on a corporate model, but it's a larger corporation.
That makes sense. Thank you for clarifying that.
Okay, thank you, Steve. This is Jim Baldwin again. Moving on to, I'm now kind of racing through this because I don't.
Jim, John Wynn here with just a question on town treasurer. I'm not familiar with, do we have a town treasurer, a full-time on-staff position as many of these other ones are? Or is that more of a volunteer, part-time, for very specific activities types of a position?
Jim Baldwin, to answer your question, it is almost an honorary role that does exist. It's by appointment of the first selectwoman, but I don't believe they really have much functions other than perhaps signing for bonds, issuance of bonds, and some rare occasions like that that require it, that may require it. But I don't think that the position is required so much as that's their basically their only purpose. We went over the town clerk supposedly depositing funds with the town treasurer, and as I pointed out before, that's really not what happens today. It doesn't go to our town treasurer. It actually goes just to the fiscal office, the finance department.
Right. So would we eliminate that as a position in the charter?
Jim Baldwin here. That's my suggestion, is that you look closely at that, make sure that it's not required by statute. I don't believe that it is, and to see whether it's something that is still necessary. Yeah.
This is Steve Mednick, just to amplify. In one of my towns, we'll find out next Tuesday whether the voters agree with the Charter Commission, but the Charter Commission just eliminated a part-time elected town treasurer position and allowed the functions of the town treasurer to revert to the finance department, so that we made allowance that whatever functions a treasurer would be required to make under statute would be undertaken by probably the finance director, somebody in the finance.
This is Brian Caffarelli. I think that maybe this is kind of in that bucket of constables that maybe before we hastily put it on the chopping block, we hear from either the administration or the treasurer, or, like to your point, Attorney Mednick, other towns that may have been inquired. My only question about this treasurer is, it's kind of odd to me that they're just on, what's the deal with why are they ex officios of the Board of Library of the Trustees?
I asked the same question the other night.
Yeah.
I don't think we're using the role that it was intended to be, personally. It's Pam Iacono. I think over time that position has defaulted to not its original intent, and I think that we need to have the discussion of, do we need to have it, or do we need to change the definition of what that person does? If that can even be done via, based on statute, I don't know.
Okay, that sounds reasonable. Thank you, Pam. John Wynn making those comments.
So Jim Baldwin back online here talking about the appointed officers. I'm going to try to just breeze through them. We've already talked about the town attorney, assistant town attorneys, and now we're coming up to section 9.5, the fiscal officer and controller. And I think that dovetails well into the discussion that we just had with respect to the treasurer. Maybe you just, wherever you have treasurer, maybe you make reference to the fiscal officer and or controller. And below that is the office of the treasurer that we just discussed. There is, it was worth pointing out, a statute, section 7-79, which is quoted here in the charter. So obviously that's something that that I'm sure we will look at with the help of Attorney Mednick. Next is section 9.7, the Director of Public Works. I believe that this has already been raised in your prior meetings, and that is deleting the requirement of having a professional engineer in the position of the Director of Public Works. I would agree with that, and I believe that most everybody is of the same mindset that it's no longer necessary. And if you'll recall, it's in part because that was when the engineering responsibilities were often covered by the Director of Public Works. But of course, we have a town engineer of longstanding, and they have their own particular role and those qualifications already. I am breezing through this. I think many of these positions, for what it's worth, the tax collector, tax assessor, are very much reliant upon state statutes, and properly the charter makes reference to those state statutes, and I think that's a good thing. But I therefore don't really have anything to add, with the exception to the tree warden, whose term is just 1 year. I scratch my head and I can't think of a reason why the tree warden has to be reappointed. Again, that's a position. Why do I keep drawing a blank on that? It's a, what is the term, John?
Classified.
Classified, thank you. The classified position. So maybe that term needs to be stated to be more consistent with the other terms that are presented for similarly situated town officers who are also classified members. When you address that, I suggest you do.
Jim, John Wynn with a question. You mentioned about the potential of not requiring the planning public works director to be an engineer. And one of the reasons was because that we have an engineering department with the staff of engineers. But we don't have any of the engineering areas listed in the appointed officers. So how do we ensure that we have the requirement for having an engineer as part of our town, infrastructure management area? If we don't have it in the charter and we've taken that requirement out, is that just a position description requirement that would be in the Department of Engineering?
This is Jim Baldwin. I think the answer lies in the fact that the charter has several areas where it provides for the creation of other, not just boards and commissions, but also other departments. And while I don't know the exact history of the engineering department, I'm confident that it flows from that section, Article 6, Section 6.1G under the Board of Selectmen, where they can reorganize departments and the like, and combine departments. So it's a department which is now well established in the town of Fairfield, like many others. So I therefore think that's why it's archaic and it's no longer necessary to have that requirement.
And
yeah,
John Mottola here. John Mottola, and I think Jim and John, I think that's probably been established by ordinance somewhere. I haven't looked at it, but I would imagine it's in there somewhere anyway.
This is Jim Baldwin. I suspect it is, like the solid waste and recycling department is the same. I know for a fact that was created by ordinance, as well as the commission, which you won't find in this document, like many others, but they do exist. And I think Attorney Mednick made the point that you really just want to set forth your most essential boards and commissions, of which we have so many, already listed, and then there are many more that are not. I think Attorney Mednick even questioned whether we should have so many listed in this document, but that's something for you all to consider. I think that the tradition and the custom of this, the culture created by this document may be worth preserving, but to take it beyond that and start identifying each and every commission or board or department that has since been created might kind of tie your hands a little bit from the flexibility that you otherwise have by virtue of the language that allows you to create, merge, and even get rid of some departments and all those. And that is an express provision presented in the charter.
Okay, thank you.
I have something, if that's okay. Pam Iacono, just back to 9.5 fiscal officer and controller A, for Steve. Could you possibly just show us other language of how other towns define the appointment and qualification? Well, not the appointment so much, actually not the appointment at all, but the qualifications for CFO? Ours says must be a certified or licensed public accountant or otherwise have experience in a financial field. I'd just be curious to know how other people list that.
Yeah, I'd be happy to do this. I just went through this exercise in position of chief administrative officer, which is a very similar type of provision. So I do have data, so we can at the appropriate time we can go through that for sure.
Thank you.
In general, what I do suggest in the department head sections, and I don't want to belabor the point this evening, is that we have a best practice standard for qualifications for people in all their positions. Rather than being specific in qualifications, we should leave that to a human resource department, but make sure that we have a, I'm not talking about eliminating duties, but I'm talking about in terms of qualification, that we should have a best practice standard for qualifications and leave it up to our administrators to establish what those are. There's some charters throughout the state, not yours, are much too onerous. I mean, you have a requirement for an engineer and that's it. But some public works provisions have multiple requirements that may have made sense in the 1950s or 60s when they were created, but don't make any sense today. So, but I definitely have some data I can give you on that. Steve Mednick again, can I just raise something, because I know Jim wants to move into the next chapter, or maybe we're not quite there. Under the accountant, I just wanted to, and I don't have any strong opinion on it, but in the tax collector section on 9.17, when Jim and I were reviewing it, I thought I just want to bring your attention to subsection D and E. Subsection D addresses accounting methods, and it's got a very specific accounting method there. I'm not sure we need to be that specific in the charter, so I wanted to bring that to your attention as a nit that we may want to look at. And then I want to put E on the list because I want to figure out what that special exemption is all about, and again figure out whether that's something that goes back to a special act. And figure out why. So I just wanted to bring that up for your attention because I know Jim was moving on beyond that. Thank you.
Jim Baldwin, thank you, Steve. I forgot to bring that one up. I appreciate you pointing that out. So I have nothing further about the planning director, animal control officer, town librarian, and the like, the fire chief, chief of police, with the exception that for both, I think you're well aware of the recommendation. It's not mine certainly, but by several others, that the requirement that they live in the town of Fairfield be deleted, essentially, and no longer have that as a requirement. Just to remind you of that. So I'm going to move on to Article 10, the permanent boards, authorities, commissions, and departments, which kind of flows from the section we were just in, when we talk about the Director of Public Works, the Conservation Director, and the like, the Director of Human Services, Social Services. So I frankly don't have any identified issues with respect to these additional boards and commissions. The only question I have is section 10.8, the Department of Public Works. It's just, I scratch my head. I'm not certain why we have that in place, and there's no, to my knowledge, and John and Pam and anyone else help me, there's no real commission that oversees the Public Works Department. However, maybe the purpose here is to emphasize, as they do in section C of 10.8, that they're to work with the Selectmen, the Parks and Rec Commission, the Conservation Commission, the Board of Ed, or other bodies as may be designated by ordinance. But it just seems to be kind of obvious to me that the Public Works Department is going to be involved in all those things, and whether you really need to present what's set forth in 10.8 at all is the only question that I would raise. The others, I think, have substantive language, such as the next one, 10.9, Board of Health. I think that that's all appropriate. Same with the Parks and Rec Commission, the Board of Building Appeals, which is largely driven by state statute. The same for the Flood and Erosion Control Board, and certainly the Water Pollution Control Authority, the WPCA. Same to be said about the Historic District Commission, and near and dear to Chris Brogan's heart is the Ethics Commission, and I think the town of Fairfield should be very proud of the robust nature of our Ethics Commission and what's set forth in section 10.15, and thankfully it rarely ever has to be used or referred to. I will move ahead and getting to the end of things here.
Excuse me, I had one. This is Chris Brogan. I had one question back on the Board of Building Appeals. I looked on the town site. I'm pretty sure this is the one I looked and didn't see it. Does that actually exist, or is there another board that is considered the same thing?
Yeah,
John Wynn here. It might be the Zoning Board of Appeals, ZBA.
Jim Baldwin here. No, I'm quite sure it's not. The Board of Building Appeals, I believe, is through the building department. But that's a good point, Steve, is to just double check on that. But I think that's required by statute. And I think it covers more than just actual building appeals. I think what also falls under that is the blight and that sort of thing, which is also covered by a town code.
Right. My only question is, if it exists, is it on, or should it be on the town? I guess the town website is outside of jurisdiction here, but it just was really a question whether it exists, or is it one of those that we've just determined, like the Board of Zoning Appeals is the same thing or something like that.
Right. I think that's an excellent point. I would say that if it's in the charter, it should be certainly referenced somewhere on the town website.
Yep.
Absolutely.
I'm sorry, and if I missed it, I apologize.
We may want to ask the building inspector at some point whether this organization exists.
Pam Iacono, section 10.5, the Police Commission and Department, and 10.6, the Fire Commission Department. Steve, I think you had mentioned other towns have one commission that oversees both. Or no, did I misunderstand you?
No. There are towns that have thought about merging functions.
Oh, okay. Gotcha.
No one has done that to my knowledge.
Okay. All right,
I've
then
left
I'm
room
not,
I've left room in charters for reorganizations of public safety, organization. This is Steve Mendick, I'm sorry for the record. For public safety institutions, you specifically have a provision that doesn't allow for reorganizations of police and fire. So it would be a total game changer to move in that direction.
gotcha.
If
Okay.
you were to do that.
I just had remembered you had
And
remarked
also a
something
lot of
about
this,
that.
yeah, over the years, and again, I'm not familiar with your collective bargaining agreements. John Mattei does a lot of this work. Very often these commissions play a disciplinary role and do end up in collective bargaining. And if they are in your collective bargaining agreement, you want them in the collective bargaining agreement. You want to have, particularly on the police side, you want to make sure you have citizen oversight in that area. And so before you would think about making any change like that, I'd really want to take a look at the collective bargaining agreement.
Yeah, no, I wasn't suggesting, I was just
All right.
following up, remembering you
Yeah.
had said something. Thank you for that.
Okay, this is Jim Baldwin again. I was getting towards the end. I think that the Article 11, Standards of Conduct, is also fairly robust and a good thing. I don't have anything to add unless Attorney Mednick or maybe one of the other attorneys thinks that something could be added to it. But I think it's fairly straightforward. Next is the budget process in Article 12, which many of you are familiar with. I don't have any changes to be made here. I do have my own observation that the budget process is a very arduous one. And it's in many ways repetitive. That being said, there is a provision here that says that this system of presenting budgets and going over budgets can be modified with the agreement of the Board of Selectmen and the Board of Finance. That has been taken advantage of in the past. Most recently, it has not, but I just point out that that provision for streamlining things by having joint meetings with the Board of Selectmen and Board of Finance is already there in principle if one would want to do that. That is, modify that system. Other than that,
This is Jay Gross.
Yeah.
Yeah, one of the town citizens asked us to take a look at section 12.8, purchasing authority. And I've read it several times, just to make sure I understand it. So I was wondering if you could just talk me through it, and you see any issues associated with the way it's written or the way it's functioned. I'd appreciate it.
This is Attorney Baldwin again, and thanks for bringing that up. This is, I think, a very important provision that's in the charter, because as many of you know, the Board of Ed budget can be increased or decreased, but not by line item. That's the special nature of the Board of Education. And what this provides in many ways, in its essence, is it gives the executive branch, the first selectman and the purchasing agent, the purchasing department, the ability to scrutinize requisitions or contracts entered into not only by other town bodies, but also the Board of Ed. And I can assure you that there have been some pretty large savings by the recent effort of the current administration to scrutinize those requests or requisitions in contracts that previous years was not necessarily done. It was more of a pass-through through the finance department and the purchasing department. So I think it's a very important provision in the town charter in that respect. And just as a practical matter, it means that the first select woman and the purchasing director have the authority to sign off, and they're the ones who are supposed to sign off on all these things.
So are you happy with it as written, or do you think it can be strengthened in some way?
I'm happy with it as it's written, as Attorney Baldwin, and like many things, you know, I think it's a good thing to use it.
Okay, thank
Ma'am,
you.
if I may say one thing, Jay, John Matola here. Jay, we're, the Board of Finance is in the process, and we're almost done with this. There's a newly drafted purchasing policy that's being formulated right now. We've hired there's a subcommittee working on it. We hired a consultant to help us draft the policy and the rules and regulations. And we should be, I think, voting on that, I think, in January at some point. So that'll help. If you're concerned and citizens are concerned that we don't have a process in place, that new policy, which should be forthcoming in the next couple of months, will give everyone more clarity with respect to the purchasing policies of the town of Fairfield.
Okay, thank you, John.
Yep.
If I may, this is Steve Mednick. I can give you some language if you want to look at it. 12.8 is pretty good, and it does call for accountability. And I think one of the outstanding features, which Jim Baldwin did talk about, is that it includes the Board of Ed. And I think that's a very, very important element. And I'm glad to see that that's been in this charter for a number of years. I have noticed in the document, and since John Matola is on the Board of Finance, in 12.9, and I've seen this, and I think I saw it in the conflict of interest section on the Article 9, you refer to bidding in here. I think you should use the broader term procurement practices, because you have competitive procurements which are not technically bidding. And so the bidding tends to be ancient language that has been held over for some time. It's a minor point, but I just wanted to make it, is that it should be, and I don't see services in this section. I see contracts, which could be services, but it should make clear that the purchases involve more than, that they are more than goods, but they're goods and services should be covered. So we can, I have some language that we could look at, but I think the language in 12.8 is pretty substantial, and 12.9 is good as well. But I just wanted to bring those points up.
Thank you, Steve. Jim Baldwin here again, and I was just winding up, actually. So I have nothing to add about the budget process, or for that matter, Article 13 about referenda. I don't know if Steve has any observations about that. And finally, there's the section 14.1 of the official seal. I think we've discussed how perhaps we, or you might, allow for the ability or the flexibility to change the official seal by deleting the reference to that which was passed or adopted by the town meeting held on July 1, 1935, rather than creating a whole new subcommittee to create a new official town seal. If that's the wish of the commission. That's it for now.
So just one follow-up, John Wynn here. In the current Board and Commission handbook, which is available on the town's website, there is a Building Board of Appeals listed 3 vacant members, 1 existing member whose last term expired in '04. So this might be something that is antiquated by some period of time, let's say. So, Jim, I'll circulate this document to you, and then we could figure out, I'm happy to help, what did this board do and who maybe the responsibilities have been taken over by another board or commission here in town.
Jim Baldwin here. Thank you, John. Yeah, I welcome it, and I am familiar with the blight ordinance and the body. Vaguely familiar with working with the people who address the blight situations, which include buildings, of course, and that's covered by the building department and the building enforcement officer or inspector. But yeah, maybe that's been kind of folded into their role. I suspect maybe that's the case.
Agreed.
This is Jim again. My only concern there would be that we make sure that, I know that there are statutory requirements for appeals on such things that can go up to the state level, you know, through an administrative process, an appeal process, and we just have to be mindful of that. And I'm sure that with Steve's help, you will be.
Absolutely. Thank you.
So I think that's it. This is Steve Mednick. Oh, I'm sorry. Commissioner Untitled looks like he has his hand up.
I'm sorry, I'm not going to belabor this, but on the, this is more of a comment because I need to really read it a little bit more clearly, but on the minority representation, section 2.2, it seems to me that we need to, minority representation on the Board of Finance should be the same as minority representation on the Board of Education, and we need to define that. And maybe I'm wrong about this. Right now, the Board of Finance is 6-3, which is fine, it makes sense, and I get that. I think for the Board of Education, and maybe I'm incorrect, but minority representation on the Board of Education seems to always be 5-4. And I think that's the result.
Yeah.
Am I right, Pam, about that, or am I wrong?
Well, the way that it falls out, yes, but it's not a requirement. So you can end up in a situation where it goes 6-3, depending on what happens with the board. But if everyone stays in their full terms and, you know, there's no vacancies, there's no, you know, filling in the middle of a you know, an off cycle, yeah, it could go 6-3.
Okay. Well, I just want to keep that in mind. Maybe I'm reading it wrong. I got to look at it a little more closely, but it should be the same for each of those boards. That's what I'm trying to say here. And it never seems to change on the Board of Education. Since we went to 4-year terms, it seems that we've always been locked in that 5-4 scenario, which, and maybe I'm wrong about this, it doesn't give voters more choice. That's all I'm saying.
I'd like to echo that too, John, and to say that I definitely want the Board of Education on for a discussion because the structure of the way this is written right now is we could have a more in-depth conversation about it when we get there, but I don't believe, and John and I have sort of both talked about this, I don't think it's functioning in the best interests of the electorate.
So I have a technical question, and maybe Jim can answer. Are the provisions, the minority party representation provisions in the Board of Ed and the Board of Finance part of your special act? Because if they're not, there should be a consistent standard for both under state law.
I don't know if it's anywhere.
This is Jim Baldwin. I would have to look back to see if that's the case, Steve. I can't tell you off the top of my head.
And it's very difficult to apply minority party representation when you have staggered terms also. You have to, but it's doable. It's something that can be done. I would want to know whether we're disrupting something that's in the special act. And if not, it's simply a function of applying the state standard under to it. So we'll figure it out. You could have you can have a stricter standard than the state standard, but you can't have a looser standard than the state statute. But we're happy to look at that.
Thank you.
So what I was
And
going to
that's all I
say,
have.
are there any other questions or any other comments? It's your commission, not mine. This has been a great exercise. You have an outstanding town attorney. It's been a pleasure going through the document with him. It's given me greater insights into the document. I hope you feel that you have greater insights as well. Our next meeting, as you know, is going to be with public officials, the elected officials. This will take place after the election on the 8th. I don't think we're going to need a continued red line session. And then the session after that on the 16th, I believe, of November is where do we go from here? And I'm trying to keep, I hope you're finding that the grid is helpful in terms of just trying to track the citizen comments, and you'll see all of Jim's comments already. Then they'll be in the next grid that you get, and my comments as well, so that by the time we are ready for the 16th, we'll have a pretty loaded up document, and we'll have to really start to think about what our priorities are, because here's the reality. On a lot of these nits, a lot of things that the town attorney has raised this evening, I think we should try to clean up mistakes. I think we should try to clean up erratic provisions, archaic provisions. There's no reason why we shouldn't fix and clean the charter. In terms of substance, you're going to have to decide what your priorities are and how we want to schedule that so that we can really deliberate in an intelligent way on the big issues. And really divide our time, use our time well between now and next May, because you'll find once we cross into January, those months are going to go by quickly. So, but I think that we're getting a good sense of what the range of concerns are, and I hope you found this useful tonight.
Most definitely. Thank you.
Yeah, thank you, both Attorney Mednick and Baldwin for this. I did find it very helpful, and based on the questions, it seems as though the rest of the commission did. And just to kind of reiterate what you were saying, just to lay out kind of the next couple of meetings for the commission and the public who's listening. 2 weeks from today is a holiday, so that week we will be meeting on Monday, November 8th. And that is going to be when we're hearing from the public officials, like you had noted. The following meeting would be on November 16th, which would be that level set. Where do we go from here? And then the intention is to have a post level set public comment session on that following meeting, which would be December 9th. So that information, if it's not updated on the website, will be outlining that. And I would open it up to any commission members who have any business that they'd like to discuss. Seeing none, I would entertain a motion to adjourn.
So moved.
All right. All
Second.
those in favor?
Aye.
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 Any opposed? Have a good evening, everyone, and thank you again.
Bye-bye.
Thank you all.
Bye.
Thank you.
Thank you, everyone, for all your hard work.